G'day everyone and welcome to video 3.2.8 for the Legal Studies Guy. Looking at class actions today, as always, starting with a quote though. Larry Winget. Larry Winget is known, apparently, I had to look this up, he's known internationally as the pit bull of personal development. He's bald, so I don't know if that's because he looks like Mr. Worldwide, or he's the pit bull of personal development in the sense that he's like a pit bull. But nonetheless, that's supposedly his nickname, I think self-titled. And he said, nobody ever wrote down a plan to be broke, fat, lazy, or stupid. Those things are what happen when you don't have a plan. Now, look, there's lots of factors that can come into I guess, how these things end up occurring. But the good part of this quote is just that idea, I think, if we apply it to our studies this year, because we're doing year 12, that, yeah, none of you have written down a plan to, go poorly at legal studies. No, none of you have written down a plan to score, say, less than 50% on assessments, whatever it is. But it's probably, if you're in that boat, it's probably because you don't have a plan. So just that reminder that one of the really helpful things to doing well in your studies, particularly in year 12, is to actually plan, to have some kind of study plan, to have some kind of goal, and then some actionable items that you're going to do to reach that goal. So if you don't have one, I would get onto it before Unit 4. So as I said, today we are at dot point 8, knowledge point 8, and this dot point is the use of class actions to resolve civil disputes. Now, class actions used to be included in an earlier dot point, used to be dot point 3.2.2, which was key concepts or key principles as they're now called. And that was the burden of proof, the standard of proof, and representative proceedings, which is what we is another term for class actions. In this new study design, that concept of a representative proceeding or a class action has been pulled out and given its own key knowledge point, which means it's going to be something that's likely to be a little bit more accessible then in terms of, I guess, the scope of question you might get. And then it comes under this same key skill that we've now looked at in two different videos. If you've already watched 3.2.9, if you haven't, that will come up. And that is what we call the appropriateness of class actions plus methods and institutions to resolve civil disputes. So basically, when would we want to use a class action? When can we use a class action? What are the benefits of it? When is it appropriate versus when might we not want to? When is it not appropriate? So ultimately, at the end of this, what is a class action and when can they be used to resolve a civil dispute? So I thought we'd start with what is a class action, and I've got a picture of a bunch of meerkats here because the essential aspect of a class action is that it is a group, so a class. So if you think about where you commonly hear the word class, you obviously hear that at school. Generally, a class is a larger group of people, and that's exactly what a class action is. It's when commonly also known as group proceedings or representative proceedings, and it's when a group of 7 or more people, that's a really, really important point, a group of 7 or more people, who we refer to as the class, bring a civil action together as one proceeding rather than initiating separate proceedings. So it's a group of people bringing a lawsuit at the same time with the same group of lawyers, against the same defendant without having to each do that by themselves. The key important thing is that every member of that class has to have suffered the same harm from the same defendants in the same or similar circumstances. So you can't just be a disparate group of people with different harms. You have to have basically suffered the same harm. And that harm obviously has to be a breach of law in some capacity. So there has to be an actionable harm under law that each of you have suffered from the same person, or the same company or the same group. And then as a result, you can join together in a way, not so much pool your resources, but use the same set of resources to then sue someone. So, for example, a really, really common sort of class action you might have is, say, a business that's been selling a faulty product Maybe the business knows their product is faulty or has issues and they continue to sell it, and they sell it for years and years. And then we find out that that product has been harming people. All of the people, every single person who has bought that product and been harmed, is then able to initiate a lawsuit together. So that's a large group of people, similar circumstances over a long period of time, all initiating a claim together. It could be shareholders in a company if a company has been engaging in deceiving or misleading practice or conduct, and then the shareholders have lost money. They could sue together. Like I said, it's people who've bought a product. A common or one that's happening or just finalised, I'll talk about later in Victoria at the moment, is basically taxi drivers and taxi companies. They all joined together and sued Uber in a class action because they said when Uber started in Australia, that obviously cost them a lot of money. It cost them a share of their market. And they were claiming that Uber had started in a way that was illegal under Australian law. And as a result, they should get some restitution for that. So 7 or more people bringing an action together, same or similar circumstances, same defendant. It has to be, or it is initiated, a class action is initiated in the name of a lead plaintiff. So it's a really important point. There is one person who is the lead plaintiff and, in a way, is the figurehead. They're the tip of the spear. They're the person whose name goes on all the documents. They're the person who is fundamentally suing the other company on behalf of the rest of the group. Every other member of the group does not have to pay. So technically, your lead plaintiff in a representative proceeding bears the entire cost burden. That's a really, really important point. They are the one who is paying the fees. Everyone else who joins a class action or is part of a class action does not pay and cannot be made to pay the defendant's costs if you lose your class action. So hopefully what I'm trying to articulate here is really, if you are joining a class action but you're not the lead plaintiff, group members fundamentally, in a way, have no risk. And this is one of the big, features of class actions that make it appropriate for people, is that individuals can join and it doesn't cost them anything. And as a result, they won't have to pay anything if they lose. So it's a real, no risk, hopefully quite a bit of reward at the end. Now, in practice, most lead plaintiffs certainly don't have the resources available to pay the entirety of the legal fees. So legal fees can get, we're talking millions of dollars. Recent or a class action that was resolved a few years ago. Can't remember the plaintiffs and the defendants. It was to do with a camping company of some kind, I think. But the legal costs ended up being $2.85 million. They settled in that case. But obviously, most individuals who are going to be lead plaintiffs don't just have $3 million lying around to pay for lawyers. So generally, most class actions are funded by either a litigation funder or a law firm. And that's where, separate to the court proceedings, the lead plaintiff will basically sign a contract with the litigation funder. So litigation funders are businesses, and their entire business model is pay for lawsuits, win the lawsuits, or have the lawsuits, engage lawyers who run the lawsuits and hopefully win the lawsuits. And then the litigation funder takes a portion of the settlement that covers, obviously, what they've paid out at the start. So litigation funders are a business that's out there that's trying to make money off class actions. Law firms will do this as well. You've probably seen lots of ads on TV for like Slater and Gordon and Morris Blackburn as law firms. And they'll often do what's called a no-win, no-fee. And that's where you, as a class action group, will sign, or your lead plaintiff will sign a contract with the law firm. And again, the law firm's going to take their fees off any settlement. And obviously, they're hoping to pay themselves very, very well. And if you don't win, generally there'll be a contract or an agreement with the lead plaintiff that the lead plaintiff won't bear the costs. So basically, it incentivizes the law firm to obviously win the case, or else they're not going to get paid for the work that they do. So that gets quite tricky and complex, but it's something that you can try and, I guess, chart out in your books or write out in slightly different ways than just in this chunk of text. But yeah, you've got all your group members with a lead plaintiff at the top, and the lead plaintiff probably has some kind of contract or deal with a litigation funder or a law firm who are effectively absorbing or taking on the risk of the costs involved to sue this defendant. Okay. If you are a member of a class action, we have in Australia or in Victoria an opt-out system. So if the set of circumstances covers you, for example, if you're suing, someone's a lead plaintiff suing a company for a faulty product, for example, you are automatically, if you've bought that product and suffered harm, you are automatically part of the class unless you opt out. So you're automatically, if the circumstances cover you, you're automatically included in the action and you're included in any settlement in the future unless you choose to leave. Now, every member of a class action, part of the process is they will try and find every person who is covered by a set of circumstances, contact them and give them the information about opting out, because you're automatically included in the group. If you don't opt out, so this is really important, if you don't opt out, you can never sue yourself. So if you don't leave the group, if you stay in the group, you are effectively barred from ever initiating your own individual lawsuit. So what they're trying to do is they're trying to make sure they get everyone who's encompassed by a situation, run one case, and as a result, not have to deal with ongoing cases, individual cases that are going to clog up the courts. And we're going to talk about the efficiency in a moment. Class actions can only be initiated in the Supreme Court of Victoria. So really, really important. So look, a lot of detail in this what slide, but really fundamentally, 7 or more people, all harmed by the same defendant, same or similar circumstances, initiating a lawsuit together, and only one person, the lead plaintiff, is taking on the risk of the costs involved. And usually they're actually not. So why class actions? And I've got this picture here for a reason, because it is about saving money. One of the really big features of a class action is the cost benefit. We know, and we'll talk about it in 3210, we know that court is incredibly expensive. And talking about it in 329, if you've already watched that, we know that there are avenues like CAV and VCAT where we're trying to either offer free dispute resolution or reduce costs for people, because going to court is so expensive. Legal fees, so the court fees, legal representation, etc. If you are a group member, you do not need to pay any of these. You are just part of the group. The lead plaintiff is obviously accepting all of that risk and usually in an agreement with a litigation funder or a law firm. What that means is if you are a group member, you might be able to bring a dispute that you wouldn't have been able to by yourself. You might have had no capacity to get legal representation. We've just looked at the need for legal representation to initiate a claim. You might have no capacity to initiate a claim by yourself, but the fact that you can just automatically be part of a group proceeding means all of a sudden you are engaged in the justice system and you've removed a cost barrier, so you therefore have access. So really, that's the fundamental central point of why we have class actions. Obviously, there's an efficiency argument as well. If you were running, 37 different individual civil claims about the same matter, wouldn't it be easier if you just dealt with them together? Clearly it would be. Because they all happen in the Supreme Court, it really ties into that concept of administrative convenience as well. The Supreme Court will, and their specialised class actions list, will take control of the single proceeding, they'll invest the resources that they need to do that in the most efficient way, whilst whilst freeing up court time across the rest of the system to continue to resolve disputes in a more efficient manner. So ultimately, that's going to reduce delays across the system and therefore improve access. So improving delays or reducing delays, I should say. Reducing delays for other matters. You can't really improve delays. There's also like an equality and fairness argument here that's worthwhile having in your, I guess, holster, but it is mostly access related with class actions. The equality argument is, if you're running all these different individual disputes, you might have people who take theirs to VCAT versus to the courts, which court, depending on the level, if it's one person's only been harmed to the extent of $13,000, they can only, go to the magistrate's court, for example, whereas someone else might have been harmed for $130,000 and they're in the county court. And obviously there's precedent and things like that that apply through the court system. But by the time you've got all these different disputes happening in different places, you might end up with inconsistent outcomes for plaintiffs. And some plaintiffs might be disadvantaged or face some disparity because of that, which is fundamentally a lack of equality. So by having all the claims resolved together, you do ensure that no one is disadvantaged, which is a fundamental equality point. And ultimately, if there is any settlement in the matter, most class actions result in settlements rather than trials. The court then oversees and approves the settlement, and the court helps distribute that settlement to all the plaintiffs. So we should see ultimately fair outcomes for individuals. And I should point out that, say there's 300 people in a class, random number, and the settlement is 300 million. Not every member will just straight up get $1 million. The court will analyze and look over, and the law firms involved, the nature of each person's claim, and then they will get a portion of the settlement that is proportionate to the harm that they have suffered compared to other group members. So we are trying to make sure that we get a fundamentally fair outcome for each individual in the class. So, as I said, the skill here is discuss the appropriateness of class actions. So, basically, when do we want to use them? We know a discussion is that exchange of opinions. So, we are fundamentally coming down to, can't spell, opinions. That does not look like opinions. We're coming down to when they're appropriate and when they're not. Like, at a pretty clear first level of this, like not a lot of nuance or I guess in-depth looking at it. They're appropriate when there's 7 or more people. They're not appropriate if there's not. Like, that's straightforward. But we probably want to be a little more complex with our understanding than just that straight up clear appropriateness argument. This was a question from an exam either last year or the year before. That was just explaining one reason for using representative proceedings, which is 100% an idea about when they're appropriate. Like, what's one reason for using a representative proceeding or a class action, which is our new language? One reason for using them is one reason why they're appropriate. And again, it's those same things that we just spoke about on the why page. They're appropriate because of the cost benefits. They're appropriate when there are 7 or more people, again, just saying that. But they're appropriate because there's cost benefits. You might be able to bring a claim that you otherwise couldn't. It creates efficiencies, and the oversight from the courts might be preferable to some plaintiffs. But when would they be not appropriate? Some plaintiffs might not want to be part of the group. If you're part of the group, you don't have that control anymore. Generally, you're losing the ability to make decisions to the rest of the group. And as a result, some people won't like that. It's their harm. It's their life. They might want to run their claim individually. And we've got to remember that if you don't opt out, you can't sue yourself. So if you lose that control and join the class action and you're not happy with what's happening, you have no ability to sue them yourself. So that's a really important point. And there is certainly an argument that at the end of the day, so much of the settlement goes to legal fees and, um, maybe to the litigation funder, that plaintiffs actually get poorer outcomes. Plaintiffs don't get actually what they deserve, and they would be better suited to running the case themselves. So they might be not appropriate if you think you're not going to get the right outcome. And that dispute I talked about before, I can't remember the name of it, where it's something to do with something along the lines of camping. But the average payout for a plaintiff in that matter, for a class member, the average payout was $633. The legal fees that were taken out of the settlement, $2.85 million. So lawyers are taking home huge portions, and they are doing large amounts of work as well. But then the average individual was taking home $633. So, yeah, argument that you might be better suited just in terms of the proportion of damages that will go into your fees and the like. An individual might get a better outcome, a fairer outcome for them if they initiate a claim themselves. We need to connect to the principles of justice still, and I've been making fairness, equality, and access points the whole way through. So you should easily be able to put some things in this table without me just reading them off. So I would recommend pausing now potentially and having a go at that. But here's a large selection of items for you. Look, equality, we know all members are getting the same outcome. They're getting proportionately compensated. No one's disadvantaged. That's fundamentally equality. The oversight of the settlement, and this is actually a really, really good point, is that individuals who have small claims but have still suffered harm, but the harm isn't, I guess, isn't large enough for them to bother with a suit themselves. The fact they can be part of the class and get that feeling of justice, get that feeling of winning against the person that harmed them, even if it was a small harm, that's fair. Like having that feeling of, I guess, winning is absolutely fair. So that's a really good point you could make. There was a recent class action against the federal government around robo-debt. And there were some people that weren't necessarily hugely financially impacted by robo-debt. There were definitely some people that were hugely impacted. It was a horrible thing. But if you look up robo-debt, there were certainly some people that only had a really small, financial impact on. But getting a debt notice from the government did cause them quite significant stress and anxiety. And the fact that they got to be part of an action that they wouldn't have been able to bring themselves, and they got to win that action and get something back, was fair. Like that's justice, which is really important. All the benefits around costs and efficiency promote access, but we know that, individuals have little say in the progress of the action. So there's a lack of engagement, perhaps, which is not access. And class actions take a really, really long time. They're really complex. So you could actually argue that they extend the time for the resolution of the disputes, which is, anti-access, even though they do provide access at the same time. Shades of grey. It's not all black and white. Lots of good links here that I'll include below in the video description. Supreme Court in Victoria, as I said, runs all class actions, only jurisdiction for it. They've got a great little website that you can actually click a button and see all of the current class actions, and you can see past resolved recent class actions as well, and read about effectively what's happened. Law firm Clayton Utz, they have a great Q&A on class actions. A lot of law firms have good Q&As on their websites on class actions because that is a really common way that they get business and make a lot of money. So worthwhile having a read of that. And this is that Uber class action that I spoke about. It's just, so as of about 10 days ago, March, or might have been a bit over a month ago, something along those lines, March or April 2024, the basically they've just had a settlement. So Uber's going to pay about $270 million to the class action members. And now they're about to go through the process of working through the distribution of that. So worthwhile having a read of that Morris Blackburn website, who have been running that class action as the law firm. It even includes a link to the litigation funder who has funded that class action. So you'll be able to read a bit more about how that works. Ultimately, you should be very clear now on what is a class action and when we can use them and why we should use them, but also why maybe they can be a bit challenging for individuals seeking justice, and some of the, I guess, the downfalls of utilising a class action. As always, comments, feedback below. Only a couple more to go until the end of Unit 3, and then we'll be jumping into the Constitution and politics and everything in between in Unit 4. Happy studying, and talk soon.